Yes.
Like the next board meeting, witness in the recommendation, so that at least everybody will. They don't know what's going on. No, that you should pick up. Oh, okay. So that the past knows. Just.
All right, Supreme Court of Guam Sound Session, Honorable Chief Justice Robert J. Torres presiding.
Hafa councils, you may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA25-008, People of Guam Plaintiff Appellee v. Stephen Keanu Camacho, Defendant Appellant. Appearing for Defendant Appellant is Attorney Stephen P. Hattori. Appearing for Plaintiff Appellee is Attorney Emily Reese. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Hattori reserves 8 minutes.
Mr. Hattori, you may proceed.
May it please the court. This is truly a case of first impression, not just for Guam, but even the U.S. Supreme Court has not addressed this particular issue. The government would like this court to judicially extend Maryland versus Craig to apply to all witnesses. The U.S. Supreme Court has not even addressed this issue. In fact, after Maryland versus Craig was issued in 1990, Crawford came out, Roberts and Melendez-Diaz came out, Arizona, Smith versus Arizona came out, and all of those, they kind of backed away from this indicia of reliability test that was also mentioned in the Craig decision. And so it's a very important decision, right? I mean, we've just gone through a pandemic, and while this pandemic is being used by the government to stretch our constitutional rights, we're asking that this court put a stop to it and refuse to break it. What the government's basically arguing is that there's a witness who, for some reason or another, it's inconvenient for him to come to Guam. And based on that inconvenience and the fact that he's needed, we should set aside Mr. Camacho's right to confront the witness in a face-to-face confrontation.
What prevents taking the deposition of Dr. Nine in Ohio in accordance with HGCA 70.55?
So the difficulty would be in transporting, well, so if they want to use it in court at a trial, then they would need to have the defendant present there, because then that would also create a confrontation clause issue. And also under the
I don't understand that that it's a confrontation. Are you saying that the defendant will not be present in Ohio?
Well, no, that's the difficulty. They would have to transport him to Ohio along for the purpose of the deposition, and also for the purposes of meeting the unavailability standard to admit a deposition transcript. They would need to prove that he is either outside the presence of the subpoena power of the court, which with the passage of the Uniform Act.
Was that explored and examined by the trial court as an option before this remote testimony was decided on?
It was not really discussed. I know that it was mentioned by Mr. Vandeveld, but the court did not seem to consider the deposition.
Is that a preferable option to your client as opposed to remote testimony to guarantee his right to confrontation?
Well, I mean, I believe that that's satisfies part of it, the face-to-face part. However, obviously, we would still try to seek his physical appearance at court, because really, nothing, at least in my mind, creates a better truth inducing atmosphere than court, right? And we all know, right? You walk in, there's a judge, you raise your right hand, you take an oath that's enforceable on Guam in front of the jury of 12, in front of the public, and in front of the prosecutor, the defense attorney, and the defendant as well.
I think Justice Scalia he said it very articulately in the dissent in Maryland v. Craig. However, as you say, this is a case of first impression, and it's a very important balancing weighing of the it's not every day that we are faced with the infringement of alleged infringement of someone's constitutional rights. In this case, the right of confrontation. However, there seems to be some jurisdictions that are willing to extend the Craig standard to other than a child witness who is a victim of sexual misconduct for that satisfies seemingly the two standards, the two elements in Maryland versus Craig in terms of furthering a public policy and ensuring the reliability of the testimony. And I'm sure we'll delve into that at this oral argument. But your argument is just that it shouldn't be even considered outside of what's already been authorized.
Uh, That's correct. I think that's the first step the court would have to do is recognize that Maryland versus Craig, which was very narrow, it applied to closed circuit testimony of a witness with just a single monitor. They weren't even talking about two-way testimony. And the specific situation of how a witness's ability to testify would be so affected by the mere presence of the defendant such that it would, basically incapacitate the witness and they would be completely unavailable. And so that,
Your opening statements is that you feel that the Dr. Nye would just be inconvenienced if he was subpoenaed to forced to come back to Guam and testify in the case. The government that sees it differently. It's not just a matter of inconvenience, but that the fact that Dr. Nye's wife is very seriously ill and she's the sole caretaker and he has a quadriplegic child, and that there are no real options for other than him to personally care for the child. Are those the facts, and is that what you say is that he would just be inconvenient rather than that there is a
I mean,
serious reason for him that he cannot travel out here?
that's correct. And I think that the record supports either finding. I think he also testified that after he relocated to Ohio, he entered into a contract with Guam to provide pathology services from May onwards. For some reason, the contract ended in October after his wife's illness and his child's treatment in Ohio was stabilized. I think he testified their conditions were static, that he actually flew to Guam 3 times between May and September of 2024, less than a year ago. So he's proven by his own, that he's been able to travel. I don't think the government could say it's impossible. And he also acknowledged that, he's not going to avoid a subpoena if he's given one. He's just looking for an alternative way of testifying. And he actually, we cited his statement about hoping to create a precedent so that this could be the way he testifies going forward.
But getting back to Justice Carbolito's question of, is it your position that we should permit remote testimony only for a child witness? And that's because Guam Rule Evidence 8041D, there's an evidentiary rule that does it, and we should not expand it to any other circumstance? Or are you saying there might be a situation where two-way video conferencing for an adult witness would be appropriate if the necessity and the public purpose requirements that were set forth in Craig were satisfied.
I guess that, I mean, that's why we have a Guam Supreme Court to make those determinations. I'm just pointing out that.
Well, I'm asking you how far, you know, from, what is your argument that we should not go beyond the Maryland v. Craig narrow circumstances, limited only to a where a child witness is involved, and an evidentiary rule also exists, and not allow expanded to any other circumstance? Because that seems to be what you were arguing or laid forth in your brief first, is that you know, to protect a child victim of sexual abuse, and the legislature has come up with this evidentiary rule, and so that's what we should limit it to, and that there would you know, is there any other public interest or important interest that might outweigh a defendant's right to face-to-face confrontation in an adult setting? Or are you saying, no, there would never be that important interest?
Well, I'm saying that, yeah, the court could determine that there is a important, compelling public interest. However, the court hasn't done so to this date, and we just went through a pandemic. I think all those other cases that extended Craig beyond a child victim seem to have been, other than that, the Giganti case revolved around pandemic-related issues. And so, and what's interesting is the Supreme Court didn't take any pandemic-related confrontation clause case up and establish an additional public policy beyond the one that was endorsed by the Craig case. And so right now, the Craig case, as it applies to Guam, is we had a legislative enactment, public law, I think 22.
Are you suggesting then that we should defer this question to the legislature and let it decide as a matter of policy, whether or not it should extend Maryland v. Craig to other than child witnesses in criminal sexual conduct cases?
I mean, that would be my preference, but I also recognize that the court can judicially recognize it as well. I just would note that this issue didn't come up during the pandemic. And, you know, the pandemic was a huge, I mean, it basically shut down travel, put everyone in quarantine, held people at the hotels from anywhere from 7 to 14 days. And despite that, we were able to conduct trials without really raising this claim. And so the Supreme Court also has not
So there
addressed
were
that.
no trials conducted during the pandemic that involved virtual testimony?
Oh, no, there were trials that were conducted using virtual testimony, and I think in those contexts, I think Morales would apply and there was a waiver. So, but what I'm suggesting is that despite the fact that we went through this really history-changing pandemic, the legislature did not enact a law that said, let's have testimony via Zoom for criminal trials. I think this court did pass some emergency rules, like the kind referenced in the Coulthard case, but none of those really allowed trial to happen without the presence, you know, outside the presence of the.
But even if the
defendant.
legislature were to enact such a legislation, it will still have to be subject to constitutional review before our court. And so maybe we're just deferring subject if we decide that that is the route to go. And maybe this is a circumstances where that may be prudent.
And that's absolutely correct. I think if the legislature, and that's what the court did in the Callahan case. The Callahan case interpreted 804.1 and imposed really the three-pronged test that the trial courts must meet or find in an evidentiary hearing to ensure that the confrontation clause rights are protected. And but you know that the public law is also important for two other reasons. It really reinforced the notion that the confrontation clause right is paramount. For example, they actually prohibit two-way video testimony by a victim. And this, I don't know if that was, I don't believe that was necessarily required by Craig, but it seemed to suggest that if a victim is able to testify in the presence of the defendant virtually, then they can do it in person as well. The second thing that really made me believe that the legislature strongly protects our constitutional right to confront our witnesses is that if in a case involving a child victim, right, if the defendant is representing himself pro se, then you cannot even use this closed circuit procedure. The testimony must be in person. And so, because they have those two conditions, it's pretty clear that the legislative intent is to protect uh, the constitutional right to confront witnesses to the greatest extent possible.
Because of our time limitation, going beyond now, whether or not Craig should be extended further than where it currently is authorized. When the trial court applied the Maryland v. Craig standards in terms of furthering a public policy and reliability, I think reliability is less an issue in my mind because of some of the advancements of two-way video conferencing that we have seen since the pandemic. But not totally, I agree. So again, I want to just go back to this, that Dr. Nine would just be inconvenience. And so that is your argument that if subpoenaed, that he would be able to address his personal circumstance and be able to travel out here. And that is just that it is not convenient for him at this time.
That's correct. I think he also referenced that he wasn't going
And
to,
is that part of the record?
that is part of the record, as well as I think he also testified that he wasn't going to get lost wages so there was a economic disincentive for him to travel as well. Um, and those line items.
So let me ask this question. If the evidence is such that Dr. Nye is the sole caretaker of a seriously ill wife and has no other options other than personally being present in Ohio to care for, ensure the care of his quadriplegic child, would that be a sufficient furthering of public policy to satisfy the Craig element of the standard, that element?
Well, I mean, I think because it just involves really personal inconvenience to the witness, that it would not arise to that level. I know that, and that was the situation. I know in Yates there was some childcare issues, and in that cold hard case, but that one I think really revolved around the fact that it was during the pandemic, as well as the fact that he had asserted his right to speedy trial, so that the California Appellate Court had to weigh the balance, right, his right to speedy trial, and could not grant a continuance. So in this case, either a continuance could be granted or possibly a deposition could be sought to allow that. So there were other alternatives that weren't
Do
really
you think
used.
a deposition of Dr. Nine and then introducing the transcript into evidence would be a more effective way? And, you know, with the, to bring that evidence before the jury than, you know, giving you the prior opportunity for cross-examination at that deposition and then remote testimony at trial as well? Wouldn't that seem to have, you know, clearly would appear to satisfy not only the right to confrontation, but the right of cross-examination, because you'd have the opportunity to be present, prior opportunity for cross-examination. And doesn't that seem to be a better solution than one where you just go in and get the transcript deposition and admit it?
No, that would be correct. I mean, it's far better than just getting the transcript in, if it's coupled with a remote testimony. But I don't believe that.
What about a videotape deposition? I always thought that we were talking about a videotape deposition.
Yeah, and videotape depositions are, they're static, so during the course of trial, other questions might arise. And so remote testimony would be better than a static deposition uh in that in that event.
So is the issue face-to-face confrontation or reliable cross-examination?
I think it's really both, because you really can't have reliable cross-examination unless the witness, is present there in front of the jury, with their palms sweaty and all the eyes looking at them, judging how they're, if they're shifting in their chair, their palms are sweaty, if their, knees are shaking. So, and that's why face-to-face confrontation is, obviously the gold standard, right? The other
I mean,
problem
when
with,
witnesses sitting in a witness box, the jurors really don't see their palms. They don't see their knees. It's protected. I mean, and if you have a two-way video conferencing, I mean, there's been some thought that in fact you can see the testifying witness better because you're a closer view. You can see if he has sweat on his brow. You can look at the facial expressions much clearer than you could if you're sitting 20 feet away or 15 feet away in a juror box.
oh, the court's absolutely correct that you might actually be able to zoom in closer with a camera. However, it's also the mere presence of being in a courtroom with all the decorum attached to it that I think greatly aids in the truth enforcing function of confrontation. The other issue too is this: they seem to get around the fact that, they about an enforceable oath. I mean, I think that's a real issue. Now that Guam's passed a way of serving a subpoena to someone in Ohio that's actually enforceable, that would make it far more reliable than, if someone's testifying by Zoom in Australia and they totally make a story up. I mean, what are they going to get charged with perjury for committing an offense in
But aren't we
Australia?
looking at it on a fact specific
Oh,
basis, a case specific, and we sort of, Craig dictates that we look at it in that manner?
yes, that's
I
absolutely
mean,
correct. So,
because, you have to examine the public purpose of those facts and the reliability that's going to be done. So, each case would have its own analysis and require, and that's why an evidentiary hearing is required.
Uh, yes, Chief Justice. And so going to that fact, so the government indicated that Ohio is outside the subpoena power of the court. So I'm not sure how enforceable an oath would be and how that would affect the reliability of the testimony of the witness. But with that,
But I thought you said that with the adoption of the law regarding service in Guam and Ohio, that doesn't seem to be an issue.
that's correct, but the subpoena, they would still have to come to Guam to appear to testify under the Uniform Act. So it just provides Guam's courts with the authority to issue a subpoena to someone within the United States and its territories. And that individual would, if they fail to report, then would be subject to arrest and forcible travel to Guam. And so even, but the government is arguing that we can't really serve a subpoena, so let's just let them testify in Ohio without any enforceable oath or without any repercussions for perjury. Not that that would be necessary in this case, given the professional nature of the witness. But this extension of Craig beyond the intended purposes of the rule would just, logically beg the next question, right? Where does it stop? Today it's the forensic pathologist. Tomorrow it might be the only eyewitness.
So are you
to this
disputing
incident.
that Dr. Nine is a critical witness in the government's case?
Uh, Definitely. The forensic pathologist is basically speaking to the jury for the victim who obviously is unable to testify. So and the government, makes the argument that he is an essential and key witness to establish the elements of their case. And their argument seems to be as long as he's an essential witness, then and he's not able to fly to Guam, then we should set aside the confrontation uh, clause requirement and just allow him to testify.
So how's the
Remotely.
government going to establish the fact of death and the cause of death that the pathologist is not able to testify?
That's correct, and that's why he's essential as
I thought you said he was an
oh
essential.
no, I'm sorry. That I agree with the government that he is an essential witness. What I'm saying is that just because a witness is essential does not mean that we should set aside my client's constitutional rights to confront him, which is what the government is suggesting, that the more essential the person is, then the less likely we need to follow the Constitution. Could I just reserve the rest for?
It's up to you.
Okay.
Yeah, you have 5 minutes remaining,
okay.
5.5 minutes.
So let me just address the Coulthard case and
Yeah,
that
of
that-
your total 30 minutes.
okay. The Coulthard case is what the government relies on to support their position, but that's really distinguishable for three reasons. One, it's a pandemic case, and I think that pretty much, even though no legislature really passed laws saying that will suspend the Constitution in light of the pandemic, many courts have recognized that that was a public policy concern that justified suspending some or part of the Constitution. And so this is not a pandemic case. The other issues were that Coulthard individual was asserted, like I mentioned earlier. So the trial court and the appellate court dealt with the fact that it was a balance of weighing his right to a speedy trial, which really prevented the option of a continuance for the court, and his right to confrontation. And so in that case, they said his right to confrontation will yield to his the right to speedy trial. And the third issue, of course, was the oath issue. And I think we've already argued that pretty thoroughly. Ohio's really not outside Guam's subpoena power. And I don't really understand the argument that they're going to be a reliable witness if we cannot hold them, charge them with perjury. In fact, that makes me believe they would be an unreliable witness.
Let me ask you, I know you pointed out that your client waived his right to a speedy trial. And you said it was really not as important that the judge recognize that proceedings in criminal cases shall be set for trial and heard at the earliest possible time. What about if this was a speedy trial case and Dr. Nine could not travel within the time frame for a speedy trial because of, the wife's medical condition, or she was hospitalized, or the child was there? What would that situation present? Would that be a public purpose that would then qualify under the Craig standard?
I think that would definitely be a factor that would assist the court in determining that remote testimony would be permitted in that instance, because the defendant's speedy trial rights would otherwise be violated. Or the court could just make a good cause finding that we're going to toll his speedy trial rights until we can have the witness testify in person.
Well, I mean, why would the defendant, object or assent to continuing the trial if he wasn't available and they weren't going to allow the remote testimony? It would seem like the defendant would rather, argue against any tolling or, and he wasn't the one that requested it. It's up to the government to produce the witness. If they want to proceed with that testimony.
No, that's absolutely correct. So then it would be a totally different appeal. And-
Anyways, you have 2 minutes, so
Okay.
maybe you might want to reserve some of your time for rebuttal.
Okay, thank you.
All right, thank you. You may proceed, Ms. Reese. And welcome to your first appellate argument for the Supreme Court.
Thank you, Your Honor. May it please,
Can you please raise the microphone and speak into it?
may it please the court. This case is, as the defense mentioned, a case of first impression, and the people would respectfully urge the court to allow the Maryland v. Craig test to apply to more than just child witnesses of sexual abuse. Courts across the country have recognized that the improvement of technology has allowed the two-way remote live testimony to increase the reliability of testimony of witnesses appearing who are not physically present in the courtroom. And this does not need a specific exception because it's already within the control of the trial court judge. So we don't need to look for a legislative enactment. We can just allow it to come in under the regular rules of evidence or criminal code because it's arguably taken orally in open court. And more specifically, it's a constitutional issue and not an evidentiary one. The Confrontation Clause provides 4 different safeguards, and the face-to-face confrontation is only one of them. It's important, certainly, and the people are not trying to diminish its importance in any way. We are saying that in certain circumstances, in line with US Supreme Court case law and federal and state case law, it can be foregone in cases where.
Well, but in this case, US Supreme Court case law has not extended Craig to circumstances outside of child witnesses who are victims of sexual abuse. To my
And only
knowledge,
one-way video, not two-way video.
That is true, Your Honor, but we do believe that the test provided in Craig is the focus of that rather than the specific facts itself. So the court did say that it wasn't going to go beyond what the facts in that case, but it also came up with a test that could be applicable in other situations, and the federal appellate courts have taken that up and chosen to apply it in the cases of two-way video conference and sometimes decided that it was a violation of the Confrontation Clause and sometimes not.
do you feel that Crawford v. Washington may have implicitly overruled Craig in reference to allowing the remote testimony in circumstances outside child witnesses?
No, Your Honor, I do not believe that Crawford is necessarily relevant here because it deals with hearsay of absent witnesses, and we are trying to bring in Dr. Nine as a witness who's subject to cross-examination. I believe that would make him not necessarily an absent witness. He's not physically present in the courtroom, but his testimony is, at the time, live, subject to cross-examination. So I don't think Crawford is necessarily implicated.
You heard Mr. Hattori here state that the government's position is that it's just or that it's a matter of inconvenience to Dr. Nine, and it's not a circumstance where there are no other options to provide for the care of his wife and his child, that would prohibit him from actually traveling to Guam to testify in this case.
And I would respectfully disagree with that, Your Honor. Dr. Nine at the evidentiary hearing did explicitly say that he had because of the extensive care required by his family, he had no family, he had no close friends that could provide the level of care that his wife and his child needed. His wife risks permanent blindness and stroke. He has a quadriplegic infant son.
But isn't that testimony somewhat undermined by his 3 trips to Guam since he moved to Ohio? I mean, why was it okay for those 3 trips and then now all of a sudden it's not appropriate, or it's an important public purpose for me to not travel anymore?
I believe, Your Honor, that the important public purpose is securing convictions of important high-level cases. And in that, to answer your question, if
But that wasn't the
conditions of
judge found.
his,
The judge found that ensuring the safety of Dr. Nine's wife and child qualifies as the important public policy,
right,
given the large distance between Guam and Ohio and the unique circumstances requiring his physical presence.
right. And if the conditions of his family were static at the time that he was able to come back, then that is, if the evidentiary hearing were held at that time, I think it would be fair to say that the confrontation clause would have been violated, but that's just one example of the test. Sometimes, a remote testimony should be allowed and sometimes it's not. However, I believe would be the purpose of allowing the evidentiary hearing, applying the factors. It won't always be the same because it is a case-specific, fact-specific inquiry, and even with the same witness, the outcome won't always be the same. And I believe also it's important to note with Dr. Nine, the reliability is less of an issue going to, again, the fact-specific part, because on his CV that he always includes when he's an expert witness, he mentions that he has testified hundreds of times in expert cases as an expert witness in at least 4 jurisdictions. So he understands the importance of an oath. This is not new to him. Even if he is not physically face-to-face with the witness or the jury and the judge, this is something that is familiar to him. He understands the solemnity of swearing on the veracity of his testimony.
Is there a statute that would provide consequences in the event he wasn't truthful?
I do believe the perjury statute applies.
The Guam perjury statute or the federal perjury statute?
Arguably the Guam
Ohio.
statute. I recognize that in our brief, we noted that he was beyond the power of subpoena. I was mentioning the regular subpoena power, but we do recognize that Guam has passed the Uniform Act to secure witnesses, and it's possible that, should Ohio recognize that.
Does that Uniform Act then prevent you from taking his deposition in Ohio?
No, but the deposition, the trial court did discuss that and found that the live testimony would be the better option.
I thought the trial court said that because of the costs and the delay, that was not a viable option.
That was the reasoning, yes. But the deposition, it is technically possible. But
What about doing the deposition and then the virtual testimony? So you have the defendant present doing cross-examination, confronting the witness at the deposition, face to face, and then having the virtual remote hearing, and perhaps being able to cross-examine and bring out any inconsistencies potentially in testimony based on what was done previously.
I believe that would be possible. I think if we're saying the problem I would foresee is that Dr. Nine would have to be unavailable in order to use the deposition. And so if we'd end up back where we are, I believe, because if he's unavailable as a witness and then we bring the deposition in, but then we ask him to testify, he's not really unavailable in the first place. So I think
Those are two different standards when you're doing, considering extending Maryland versus Craig and considering whether to take a deposition testimony.
yes.
I don't submit that those are the same cost factors to establish.
Yes, but if we're using both at trial, then I think we wouldn't be able to include the deposition testimony.
Oh, I see.
Yeah, because
Yeah.
he wouldn't be unavailable.
Right.
And I think it is important to note that allowing remote testimony in some cases is not a complete blanket rule that allows it in all cases. However, if we were to come up with a ban on any remote testimony, that would have significant consequences, specifically for homicide cases. The people are aware of at least 8 pending cases, including this one, where Dr. Nine was the medical examiner, and effectively those would be prohibited from moving forward. And in the interest of justice and allowing severe cases to move forward, which is an important public policy.
But he waived his right to a speedy trial. So, I mean, there wasn't the pressure that you had of trying to get him, here in the time frame to, meet his right to a speedy trial.
And we do recognize that timing can create what can be referred to as an inconvenience or necessity, but at least one federal court, I believe, has found that an uncertainty about when the issue of what was creating that a witness's unavailability has been enough to allow a remote testimony. So that was in the case of, it was actually someone who had not tested positive for COVID, but was quarantined. And the court said, well, we don't know when, if you test positive, we don't know how long that will continue. So it's possible that, because of his wife and his son's condition with Dr. Nine, we don't know when that will be static enough for him to come back. And I believe we could continue the trial indefinitely, but there's also GCA 8050, I believe, requires expeditious handling of criminal trials. So that would be arguably contrary to the spirit of that statute.
Yeah, but I don't think we can say that outweighs the constitutional right to confrontation.
It may not in itself, but the effect of the weight placed on one witness to choose between his family's health when we don't there's no evidence in the record to indicate that there will be another period of stasis where he can come back. I think it's possible he came back initially because of the extreme difficulties Guam has in finding medical examiners, and if they were, that was when he first left, so I don't know if their condition had not I don't want to hypothesize because I don't believe it's supported by the record, but I also don't believe there's anything to suggest that he believes that his family is likely to improve. And without that, I don't think that we can wait indefinitely, especially when we have the safeguards in place that the confrontation clause generally requires. We have an oath, we have the ability for him to view the jury and the judge. And he has done this once before, and the results were fine. The defense did not have issues, as far as I know. The prosecutor handled the case went smoothly. So there is a procedure in place that can handle this. And I think it's just important to note that this is a narrowly tailored case. We're not asking for a broad exception, but allowing this to proceed would set a standard for trial courts to apply in the future. And disallowing it or having a blanket rule against it would effectively bar prosecution for at least 8 homicides, which would not be in the public interest or the public policy. And I would like to circle back to the evidentiary issue. Again, I think the focus on 804.1 is
why shouldn't we look at like the rule in Crawford where it discusses it, in terms of the confrontation right being absolute for testimonial evidence unless the witness is unavailable and the defendants had a prior opportunity for cross-examination. If we look at it under that standard, what would the result be in this case?
I believe the rule also refers to a preference.
So we've indicated he may not be unavailable under the term of especially with the subpoena powers, the adoption of the uniform subpoena rule. And so if the witness is potentially available, and then the opportunity for cross-examination, if the defendants had that opportunity.
Not a prior opportunity for cross-examination, but certainly the live testimony would be, that seems to be the crux of most confrontation clause cases. And the live testimony arguably,
I'm sorry, you got to speak up a little.
sorry. The live testimony arguably provides that, at least within the jury, at the time of trial, better than something like a deposition would, because it's happening in front of the jury, and as opposed to something being read or even viewed. So I think as far as, cross-examination goes, even if there's something like lag, or there have been cases that said even disruptions with the live stream don't necessarily interfere with the confrontation clause, because as long as there's something in place that allows it to be rectified, the defendant's rights are not necessarily violated. And so I think with the way, it's almost instantaneous, and I think the cross-examination standard is certainly met. And that,
So you're saying that the fact that he can appear virtually gives them the opportunity for cross-examination and makes him available, and therefore we don't need to look at that being a diminishment of his right to confrontation?
I believe it needs to be considered with all of the other protections that Craig mentioned and guaranteed in that the clause guarantees. So there's the face-to-face, he's not necessarily available because of confrontation, but and of course the rights are always considered, but face-to-face is not an absolute right. It's one of four, I forget how the court phrased it, but it's one of four parts of the confrontation clause, and in the right circumstances, in very rare circumstances, which are present here, it doesn't necessarily have to exist. There are also jurisdictions, actually, like Ohio, that Ohio's state constitution has in its confrontation clause the words face-to-face, and even Ohio has found that physical face-to-face confrontation doesn't necessarily have to exist. So even when there are cases or jurisdictions that emphasize the need for the physical presence of a witness, there are always other considerations, because courts generally recognize that it's not an absolute right. And I think here, the other protections are easily in place.
Do you see that there's any difference between having the person sit in the courtroom and appearing on Zoom in terms of rights under the Sixth Amendment?
I can see that there may be some difference to the witness. However, in this case, I believe that Dr. Nine's experience is significant enough that he understands the rights or understands the importance of taking an oath. I also believe that the oath itself is protective enough in most cases. So I think as long as the evidentiary hearing takes place, and like in this case, Dr. Nine was, the judge asked if he knew that he would be under oath. Dr. Nine affirmed this, and as long as that is in place and it is clear that the witness understands this, I believe that that should be sufficient. And I would finally like to just differentiate the cases that have discussed inconvenience. Many of those have been state expert witnesses refusing to miss a day of work or not wanting to drive across the state. Some have not wanted to travel for one day, and while travel from Ohio to Guam would essentially be one day, it is significantly different in the sense that it would be 7,500 miles, at least one layover, a 14-hour difference. And I don't think we can call this mere inconvenience, especially when Dr. Nine has a very ill wife and child at home, who require his care. And I think the cases are easily distinguishable in that sense.
You brought up the four factors you were discussing. I mean, I presume that you're talking about physical presence, the oath, the opportunity for cross-examination and observance by, right?
Yes.
But don't those factors, those four factors all go towards the reliability aspect of it? And you still have to address the public purpose as separate from that? I mean, and so that, I mean, that's what happened in Craig. They said as far as the reliability was concerned, the physical presence wasn't there, but three of the four factors were present. And so therefore, you know, you could proceed. But to me, that addresses the reliability aspect of it. And it doesn't seem like there's been much discussion challenging the reliability of the and the second prong, even acknowledging when physical presence isn't satisfied as one of those factors. But that doesn't address you know, the denial of face-to-face confrontation being an has to further an important public policy aspect of it. And so, you know, we're talking back here again of, and the advancement of the important public policy, say, well, it's the health of Dr. Nine's wife and his child. And that's what the trial court seemed to believe. The defendant argues that that's more for the convenience of him, and that's not really an important public interest. And you know, you cited, well, there were potentially other public interests that might have been referenced, including the right to speedy resolution of cases, and then the fact that Dr. Nine's testimony, I guess, was critical as a critical witness.
Yes, Your Honor. And I do believe the trial court cited the speedy resolution of criminal trials. And I also think it's important, again, to mention that this particular witness is an integral part of the government's case, because without him, it could not proceed. It's simply.
But doesn't the importance of a witness suggest that it's more important then that you have that face-to-face confrontation? I mean, he's not an ancillary witness on some factual, establishing some factual occurrence. This seems to be a critical witness to the government's case, and Mr. Hattori argues he's really speaking for the victim, the deceased.
I do understand your concern, but I believe that's why the reliability is the second prong. And as long as those factors are in place, I believe that the testimony should still be allowed in. And I think here, as we've mentioned, there's not a lot to challenge reliability. So, well, he is a critical witness. I don't think that hurts the government's position. I think it actually helps because it adds to our policy. There are 7 other cases at least. And yes, that would each one of them would have to go through the same evidentiary hearing. It's not a blanket allowance for all of them. But this witness in these very specific circumstances is important to the public policy of adjudicating homicide trials, and homicides are, of course, one of the most serious crimes, and allowing the jury to meaningfully consider all of the evidence is important to ensuring that the trial is conducted fairly.
I think your time, you have 10 seconds left. Any final parting words?
No, Your Honor.
Thank you. Mr. Hattori, you have 2 minutes.
Yes, Your Honor, I just want to wrap it up by saying if the court is going to apply the Maryland Craig standard, v. Craig standard, then obviously the public policy concern is the main issue. The government seems to believe that we should have a sliding scale of constitutional rights. The more serious the charges, the fewer constitutional rights you have. We've just, been through the pandemic. The U.S. Supreme Court did not even find that the pandemic itself was a compelling public interest to allow wholesale trial by Zoom. And so, and the Supreme Court's actually addressed this issue. We referenced in an FRD where they were considering the criminal procedure rule that would allow, similar to civil cases, testimony remotely. And that's one of the just quotes Scalia famously said, virtual confrontation rights might be sufficient to protect virtual constitutional rights. I doubt whether it is sufficient to protect real ones. And I think additionally, one could even go further and say, how could a virtual oath, which is what the government wants Dr. Nine to take, be enforceable given, the government's belief that Ohio is beyond the scope of the court's subpoena power, as well
Federal
as
perjury statute?
that's correct. That's probably the only avenue, and the likelihood of that happening, obviously, I is I would assume is remote. And so breaking a virtual oath is not akin to breaking an oath rendered in a public courtroom in the physical presence of a judge, the jury, the public, and most especially the defendant who possesses the right to confront that witness. We hope that the court declines to extend Maryland versus Craig. All right, thank you.
Thank you, Mr. Hattori. Ms. Reese, the court will take the matter under advisement. We'll issue a written opinion and will now stand adjourned.
All rise.